All right, Saturday morning, a 147-page document production hit the public docket, and two of the most powerful law enforcement officials in the country had no warning it was coming. Kash Patel, Pam Bondi, named in a federal compliance order, with a financial penalty clock already running. I've been inside these documents since Friday night. Here's what I found. Because this isn't just a missed deadline story. It never was. It's about what Judge HANKS did differently this time. It's about the coordination call on page 112 that nobody disclosed. And it's about the career attorneys who started filing for reassignment before the ink was dry. Let's get into it. Quick context first. Judge HANKS, Federal District Court, Washington, D.C. This isn't his first high-profile matter. You know that. The issue here is a standing judicial production order requiring the Department of Justice to turn over specific internal communications tied to prosecutorial decision-making. Communications that Patel's office had shielded under deliberative process privilege. Bondi's team publicly backed that position. Judge HANKS looked at it, disagreed formally, and put it in writing. Now here's where the timeline gets important. Weeks back, DOJ attorneys filed a last-minute motion to push the production deadline, cited internal review protocols, cited sensitivity of materials. Standard language. 10 days ago, HANKS denied the delay. No press release, no fanfare, just a denial. This past Thursday, the production deadline hit. DOJ missed it. Completely no filing. No extension request. Nothing. Friday morning, 9:47 a.m., HANKS issued the compliance order anyway. With teeth. Daily financial penalties. Public simultaneous release of all 147 pages. No advance notice to DOJ counsel. That's the setup. Now the documents. Because what's inside that production isn't just procedural paper, it's a trail. And it leads somewhere neither Patel nor Bondi acknowledged publicly. First document, filed Thursday, June 5th. Page 31. I pulled it directly. The language reads, internal directives issued between January and April reflect a deliberate decision to withhold responsive materials pending senior leadership review. Read that again slowly. That's not my interpretation. That's the filing's own language. What it means in plain English is someone above the career attorneys, someone in senior leadership at the Department of Justice, made a conscious decision to hold documents that a federal judge had already ordered produced. That's not a filing error. That's not a calendar mistake. That is a decision with a name attached to it. But that's not the detail that stopped me cold. Page 89. Different section. Different tone entirely. Buried inside what looks like a routine document index are 23 internal emails, all from the same 4-day window in late March. And those emails are about one thing: how to describe the withheld materials in a way that avoids triggering Judge HANKS's original production order. The phrase they kept landing on? Reframe as advisory. That phrase appears 11 times across different email threads. Different authors. Same language, same goal. You put page 31 and page 89 together, and the picture that forms is not accidental. It is coordinated. I went through that section 4 separate times. The pattern doesn't disappear on reread. It gets clearer. Here's the sequence as the documents show it. DOJ receives the original production order, acknowledges it in senior leadership, and the filing specifically names the office of the director, issues an internal hold. Career attorneys below that level begin flagging the hold as a compliance risk. In writing. On the record. All of it documented inside Friday's production. Those career attorneys were right to be worried. Because what happened next is what nobody in the mainstream press has focused on. Page 112. One paragraph. A notation from Bondi's office. Dated March 19th. Referencing a coordination call between the Attorney General's office and Patel's team at FBI specifically about this production. A call. That was never disclosed to Judge HANKS. Let that settle for a moment. The Attorney General's office and the FBI Director's office coordinated on strategy around a pending court-ordered production and did not tell the judge. That is not a footnote. That is the central question this entire case now turns on. Because courts don't just dislike surprises. They treat undisclosed coordination on pending matters as a potential candor issue. And candor issues are a different category of problem than missed deadlines. Here's what that means practically. HANKS's compliance order carries a daily financial penalty of $47,000. DOJ missed the original deadline on June 3rd. As of Friday evening, they were already 4 days past. That's $188,000 in accrued penalties. By Sunday morning, you're approaching $250,000. And the clock hasn't stopped. 2 career prosecutors named in the documents filed for internal reassignment last Wednesday, before the production even dropped publicly. That tells you something. A third-party law firm retained to assist with the document review submitted a letter to the court on Friday. Their letter said their own review was incomplete because the client, meaning DOJ, had imposed access restrictions. Attorneys telling a federal judge that their own client blocked them within 72 hours of the document hitting the public docket. That's where we are right now. Now because the other side has real arguments and this breakdown doesn't work if I skip them. DOJ defenders, and serious ones exist, say the deliberative process privilege isn't invented. It's established law. Courts across circuits have recognized that internal government communications about how decisions get made deserve protection specifically because you want officials to be able to deliberate without every internal conversation becoming a litigation exhibit. That part holds up legally. It genuinely does. They also argue that HANKS's original production order was deliberately broad in scope and that DOJ wasn't acting in bad faith by pushing back. Complying with every expansive judicial production order without privilege review would create its own set of legal problems. That's not obstruction by definition. That's a former Deputy Attorney General who has argued privilege disputes under 2 separate administrations made this point publicly. Coordination between DOJ leadership and FBI leadership on a pending matter isn't inherently improper. It is sometimes operationally required. Even the third-party review firm's letter, which sounds alarming, acknowledges that access restrictions in matters of this sensitivity are not unprecedented. The March 19th notation on page 112. Critics of the alarming read say it's a single calendar line in 147 pages. It doesn't describe what was discussed on that call. It doesn't confirm that anything improper was said. It confirms a call happened. Treating a calendar notation as a smoking gun, they argue, is a significant stretch. I don't agree with all of it. But I'm not going to pretend those arguments don't have weight. Because they do. Deliberative process holds in the D.C. Circuit specifically. The coordination call standing alone establishes contact, not wrongdoing. Here's what I will say. Both things can be true simultaneously. HANKS's reading of the evidence pattern can be legally supportable, and DOJ's privilege argument can be legally legitimate. The question isn't which one exists. The question is which one a federal judge with full access to the unredacted communications decides controls. And right now, that judge is HANKS. And HANKS has already shown which direction he's leaning by what he did Friday morning. Let's talk about backstory. Because this didn't materialize from nothing. 8 months ago, HANKS first designated this case a priority compliance matter internally. No public announcement, just a quiet flag in the docket. DOJ acknowledged it in a routine status filing and committed to production within standard timelines. 5 months back, first production deadline passed. DOJ filed a 1-page extension request. Court granted it without comment. 6 weeks ago, second deadline passed. This time DOJ filed nothing. No extension request. No status update. Silence. A scheduling conference happened around that time. The court's own notes from that conference include this language. The court notes the absence of a status update from the government. That's a judge writing into the official record that the government goes. DOJ's response to that notation. Nothing. If that pattern sounds familiar, it should. DOJ has run a version of that same play in at least 4 other matters over the last 2 years. Acknowledge the order publicly. Request a delay through proper channels. When proper channels run out, go quiet and wait for the matter to drift down the docket. It has worked before. Until Friday. Because HANKS didn't wait this. He issued the compliance order and released the full 147-page production simultaneously to the public docket. No advance notice to DOJ counsel. No courtesy window to seek emergency relief before public exposure. Public first. Response second. That's the move that changed everything. Let me tell you what happened Friday morning in real time. 9:47 a.m. HANKS's office pushes the compliance order and the full production to the public docket simultaneously. Reporters in the courthouse describe the room as going quiet. Within 40 minutes, DOJ's press office issues a 3-sentence statement. The department is reviewing the court's order and will respond through appropriate legal channels. That's the full statement. 3 sentences. No factual dispute. No time. No denial of the coordination call notation. Legal reporters covering the case noted immediately that the statement didn't challenge a single factual claim in HANKS's order. Not one. 11:15 a.m. A separate filing appears on the same docket. Different case number. Same parties. 11 pages. A motion by a nonprofit legal watchdog citing HANKS's production as grounds to reopen a FOIA action that had been dismissed 18 months earlier. That motion was ready. It was waiting. The moment the production went public, that filing followed within 90 minutes. By 2 p.m. Friday, Bondi's office had made 3 separate calls to the court clerk's office. All logged. All asking about the process for filing an emergency sealing motion. 3 calls in 4 hours. Then late Friday evening, reporting from 2 separate legal correspondents confirmed that the emergency sealing inquiry had been informally rebuffed by the clerk, not officially denied yet, but turned away. Patel's communications team, meanwhile, went completely silent on the subject. No background comment to reporters. Dark by 3 p.m., 2 congressional offices confirmed receipt of the full document set, not a courtesy copy. Staffers, plural, were working through the materials. HANKS's order didn't just release documents. It unlocked a chain reaction that was already positioned to move the moment those pages went public. The FOIA reopening. The congressional receipt. The penalty. The reassignment requests. None of that is coincidence. The sequencing tells you this moment had been anticipated by more than one party, and only one of those parties was caught off guard. Now, what are legal professionals actually saying? Former federal prosecutor, D.C. District, 19 years of experience, handled privilege disputes under 3 separate administrations. His read on the simultaneous publication. When a judge publishes simultaneously rather than sequentially, he is no longer treating this as a procedural matter. He's making a statement. He's removing the option of a quiet resolution. The window that normally exists between judicial order and public release, that's where emergency motions happen. HANKS closed it. Deliberately, plain English version. HANKS didn't just enforce the order. He made sure the enforcement was public before any motion to stop it could land on his desk. Second voice. Former Assistant United States Attorney, Southern District of New York, currently in private practice. His focus landed immediately on page 112. The coordination call notation is the detail I'd be tracking. Courts don't like surprises, but there's a specific category of surprise that triggers formal inquiry. If that March 19th call touched on production strategy for this matter and was not disclosed to the court, you're potentially looking at a candor issue, not just a compliance issue. Candor, that word matters. It is not a procedural violation. It is a conduct violation. And conduct violations at this level carry consequences that extend well beyond financial penalties and document disputes. Third perspective. Constitutional law professor at Georgetown who has publicly defended executive privilege positions in prior administrations. Even this voice said publicly that the pattern of 2 deadline misses followed by silence in the same matter is difficult to characterize as inadvertent. When legal professionals who defend privilege on principle are saying the pattern looks bad, the pattern is. The legal exposure here has shifted categories. What started as a procedural production dispute has crossed into substantive conduct territory. And the coordination question, disclosed or undisclosed, is now the center of gravity for where this goes next. Why should you care? Because this lands on real things. The $47,000 daily penalty in HANKS's order doesn't live in abstract legal space. It accrues against the Department of Justice budget, which means it accrues against the federal budget, which means if you pay federal taxes, the financial consequences of this compliance failure are yours too. At current pace, by end of business Monday, you're looking at well over $200,000 in penalties from a single missed production deadline. If DOJ contests the penalty structure and this moves to appeal, total legal costs on both sides run into the millions. All of it. Public money. The precedent dimension matters separately. HANKS's simultaneous publication model is now in the record. Next time a federal agency receives a production order it finds inconvenient, the HANKS playbook is on the table as a counter option for any judge who decides the standard courtesy approach isn't working. That changes the risk calculation for every agency managing sensitive document requests right now. Not just DOJ. Every agency. If you have ever submitted a FOIA request that came back incomplete or heavily redacted, the legal theory being advanced in the related FOIA reopening could affect how courts treat similar denials going forward. Right now, approximately 340 pending FOIA and judicial production matters involving DOJ are being watched more carefully by attorneys on both sides in light of Friday's order. Legal watchdog organizations, journalists, and congressional oversight staff who have filed document requests in the last 18 months are actively reviewing their own cases this weekend. And then there is the uncomfortable dimension. If the coordination call notation leads to a formal candor inquiry, we are no longer talking about document delays and financial penalties. We are talking about potential disciplinary proceedings against currently sitting senior officials. That is not hypothetical. That is the procedural pathway when candor to the tribunal allegations advance past the inquiry stage. The process exists. It has been used before. It moves slowly, but it moves. What informed people are doing right now. Pulling the full docket on Pacer. It's public. No paywall. Watching whether DOJ files an emergency sealing motion before end of business Monday. Reading the nonprofit legal watchdog's FOIA reopening motion specifically. Because the theory it advances will tell you a lot about where the related litigation is headed. And asking the question that HANKS himself may ask Wednesday morning. Were there additional internal DOJ communications responsive to the original production order that were not included in Friday's 147-page drop? That question hasn't been answered yet. It may be the first question out of HANKS's mouth at the status conference. How did Patel and Bondi's offices respond? Let's go through it exactly. DOJ's official statement. The full text. Released within 40 minutes, The department is reviewing the court's order and will respond through appropriate legal channels. That is 3 sentences. It disputes no facts. It makes no timeline commitment. It does not address the coordination call. It does not address the financial penalties. It does not address the career attorney reassignment request. Legal reporters who cover this beat flagged the statement's silence on the substance as notable within the hour. The nonprofit that filed the FOIA reopening motion cited DOJ's non-response to the factual record as acknowledgement by silence in a follow-up filing posted Friday afternoon. HANKS' office issued a scheduling notice by end of day. Parties are directed to appear for a status conference at 10:00 on June 10th. That's Wednesday. Both sides, in person. The late Friday reporting on Bondi's emergency sealing inquiry being informally rebuffed means DOJ heads into Wednesday's conference without the emergency relief they clearly sought and without a public posture that addresses the substance of HANKS' order. That's not a strong position to walk into a courtroom with. Here's what's still unresolved. 1. What was actually discussed on the March 19th coordination call? The notation confirms the call happened. The substance of what was said does not appear in Friday's production. Whether that omission is itself responsive to the original production order is a question HANKS is almost certain to raise Wednesday. 2. The career prosecutors who filed for reassignment. Their internal memos documenting why they sought reassignment, if those memos exist and if they're responsive to the original order, may not have been included in Friday's production. That gap is sitting in the record right now. 3. The privilege log. Patel's legal team is reportedly preparing a formal index of everything they're still asserting protection over. That log is due Friday, June. What ends up on that list will tell you more about the scope of what's still being withheld than anything released so far. Date to watch. Wednesday, June 10th. Status conference, 10:00 a.m. All parties required in person. If HANKS asks the question everyone expects him to ask about undisclosed coordination and completeness of the production, this escalates. After that, Friday, June 13th, privilege log due from DOJ. Monday, June 16th, deadline for third-party interveners in the FOIA reopening to file supplemental briefs. 3 weeks of filing deadlines stacked on top of each other while a $47,000 daily penalty continues to run. That's not a case that's cooling down. That's a case that's accelerating. Here's where we actually are. 147 pages live on the public docket, available to anyone right now. DOJ penalty accruing at $47,000 per day since June 3rd. No emergency stay has been granted. 2 career prosecutors formally requested reassignment. A related FOIA case has been reopened citing Friday's production. Congressional staff at 2 offices have confirmed receipt and are actively working through the documents. Status conference Wednesday, June 10th at 10:00 a.m. Privilege log due Friday, June 13th. Third-party intervener briefs due Monday, June 16th. And the one thing still sitting unanswered in the public record. A calendar notation on page 112. 1 paragraph. A coordination call between the Attorney General's office and the FBI Director's office about a pending court-ordered production that was never disclosed to Judge HANKS. That notation doesn't prove what was said on the call. It doesn't establish wrongdoing by itself. But it is the question that everything else now orbits around. Because if that call touched on production strategy, and if its omission from the court's awareness was intentional, you are no longer in compliance territory. You are in candor territory. And candor territory is where careers end. HANKS didn't publish 147 pages simultaneously without advance notice by accident. Judges at that level don't make procedural choices like that accidentally. The simultaneous release was a message. The FOIA reopening filing that appeared 90 minutes later was ready and waiting for exactly that message. The congressional receipt, confirmations by 3 p.m., tell you the documents traveled fast to the places that matter institutionally. This was not a routine compliance enforcement. Every choice in Friday's sequence was deliberate, including the ones that made sure there was no quiet window to make it disappear. Wednesday's status conference will tell us how far HANKS is prepared to push. The privilege log due Friday will tell us how much is still being protected and what Patel's team is betting the court won't be able to force out. And the FOIA reopening brief due the following Monday will tell us whether the legal theory that could reshape how document denials are treated in federal courts has legs beyond the initial filing. The Court Nation call on page 112. One paragraph. 147 pages. That's the ratio. And that paragraph may be the one that determines where all of this lands. Clock's running. Wednesday is 4 days away. Story's not over. It's